Hello everyone, this is Dr. Satish S. Bornare, Department of Genetics and Plant Breeding, KK College of Agriculture, Nasik. Today we are going to learn the topic environmental legislation. So friends, India is the first country in the world who have made the provisions for the protection and the conservation of the environment in its constitution. On 5th June in 1972, environment was the first discussed as an item of the international agenda in the UN Conference on the Human Environment in Stockholm. And thereafter, in the 5th June, is celebrated all world as a World Environment Day. And soon after that, Stockholm Conference, our country took substantive legislative steps for the environmental protection, and the Indian government has passed different act for the protection of the environment. So India became the first country in the world who have made the provision for the environmental protection. And after that, the Stockholm Conference, India have took a legislation step for the environment protection and passed the different number of environmental protection act. So let us see the different protection act, in which first is the wildlife protection act in 1972. Then after, the water prevention and control of pollution act in 1974. Then after that, the forest conservation act 1980. Then the air prevention and control of pollution act in 1987, and the environment protection act 1986. There are a number of laws passed by our government, but out of that, these 5 laws are important for the protection of the environment. And we now let us see the details of the important 5 laws passed by our government for the environment protection. So what is the constitutional provisions made by the government? The provisions for the environmental protection in the constitution were made within the 4 years of the Stockholm Conference in 1976 through the 42 amendment as follows. The Article 48A of the Constitution provides the state shall endeavor to protect and improve the environment and to safeguard the forest and the wildlife of the country. So, according to this Article 48(7), this provides the rights to the state to protect and improve the environment by the safeguarding forest and wildlife of the country. Then Article 51A of G provides it shall be the duty of every citizen of the India to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and have to compassion for the living creatures. So this Article 51G gives the role of the every citizen of India to protect the environment by different means or different living creatures. Thus, our constitution includes the environmental protection and the conservation as one of our fundamental duties. Through constitutionally, we are avoidable to protect our environment. Then, let us see the first act passed by the Indian government, which is the Wildlife Protection Act 1972. It defines the wildlife related terminology. So this act defines firstly the wildlife related terminologies. Then it provides for the appointment of wildlife advisory board, wildlife warden, and their powers and duties, etc. in detail. So this Wildlife Protection Act details everything about the wildlife, their constitution structure, and the authorities, powers and duties, etc. Under this act, the comprehensive listing of the endangered wildlife species was done for the first time, and prohibition of the hunting of the endangered species was mentioned in the particular act. So this is the first case or first time the comprehensive listing of the endangered wildlife of the Indian species was done, and first time the prohibition of the hunting and endangered species was mentioned in the Act. Then after the protection to the some endangered plants like beddown, cycad, then blue vanda, lady's slipper orchid, then pitcher plants, etc. is also provided under this Act. Then the Act provides for the setting up national parks, the wildlife sanctuaries, etc. The Act provides for the constitution of the Central Zoo Authority, and there is provision for the trade and commerce in some wildlife species with license for the sale, possessions and transfer, etc. So this Wildlife Protection Act gives the total framework related to wildlife. And the Act imposes ban on the trade or commerce in the scheduled animal. It provides for the legal powers to the officers and punishment to the offenders, and it also, the beauty of this Act is there are punishment or legal powers are given to the officers who are the offenders. Then it provides for captive breeding program for the endangered species, so that these endangered species are become out of the endangered and become normal species. Then several conservation projects for the individual endangered species like lion in 1972, then tiger in 1973, crocodile in 1974, and brown antelope deer in 1981 were started under this Act, and through this Act these endangered or going to endangered or rare species are conserved under the different conservation project. The Act is adopted by all states in India except Jammu and Kashmir, because the Jammu and Kashmir has its own Act. Major drawback of this Act is mild penalty to the offenders and illegal wildlife trade in J and K, that is Jammu and Kashmir. Then personal ownership certificate for the animal articles like tigers and leopard skin, and no coverage of the foreign endangered wildlife, pitiable conditions of the wildlife in mobile zoos, and little emphasis on protection of the plant genetic resources. So these are the some of the drawbacks of the Act, in which the mild penalty is given to offenders, and there are certificates, personal ownership certification are also provided, through which the tigers or leopard skins are in danger, and no coverage of the foreign endangered wildlife species, and some of the pitiable condition of the wildlife in mobile zoos, and little emphasis is given on the protection of the plant genetic resources. These are the major drawback of this Act. The second Act is the Water Prevention and Control of the Pollution Act in 1974. This Act provides for maintenance and restoration of quality of all types of surface and groundwater. It provides the establishment of central and state boards for the pollution control. So through this law, the Central Pollution Control Board and State Pollution Control Boards are established. And this law confers them the powers and functions to the control pollution. Then the central and state pollution control boards are widely represented and are given comprehensive power to advise, coordinate and provide technical assistance for the prevention and control of the pollution of the water. So in all respect, the powers are given to the central and state pollution control board to manage all activities related to the water through this law. Then the Act has provision for the funds, budgets, accounts and audit of the central and state pollution control boards, and through this Act there are a clear-cut view or clear-cut mention there the monitoring or fund allotting or budget or accounting or auditing of the state and the central pollution control boards. The Act makes provision for the various penalties for the defaulters and procedures for the same. So by this law, there is provision for the penalties for various kinds of the defaulters, and procedure is given in detail in this law. Then the Act has made a detailed provision regarding the power of the boards to obtain the information, take the trade sample, restrict new outlets, restrict expansion, enter and inspect the units, and sanction or refuse the consent to the industry after the effluent analysis. So this Act also comment on the different effluent analysis and gives powers or made provision regarding the powers of the boards for the overall activity related to the water and water quality. Then while development is necessary, it is all the more important to prevent the pollution which can jeopardize the lives of the people. And despite certain weakness in the Act, Water Act has ample provision for preventing and controlling water pollution through legal measures. So there are some weakness is observed in this Act. Besides that, the Water Act is having a good control over the water pollution through the legal measures, and by this law, the major statement is made that the development is necessary. It is all more important to prevent the pollution which can jeopardize the lives of people. Then the third is the Forest Conservation Act 1980. The state government has been empowered under this act to use forest only for the forestry purposes, and if at all it wants to use it any other way, it has to take a prior approval of the central government, after which it can pass order for the declaring some part of the reserve forest for the non-forest purposes, for example mining and or for cleaning the some naturally growing trees and replacing them by economically important trees, that is reforestation. So through this law, the state government have the power to act or use the forest for the forest purpose, but if the state government wants it for the another purpose or for the commercial purpose or for the non-forest purpose, the state government have to take the prior approval from the central government. Then it makes the provision for the conservation of the all types of forest for these purposes, and there is advisory committee which recommends the funding for it to the central government. So through this act, it makes provision for the conservation of all type forest, and for this purpose there is an advisory committee and which recommends the funding for it to the central government. So through this advisory committee, the fund from the central government is made. Then any illegal non-forest activity within a forest area can be immediately stopped under this act, and if there is any non-forest activity any non-forest activity is observed without prior permission of the central government, then this act is have provision to stop this activity immediately. And in 1992, there is amendment is made by the government in the Forest Act, which includes some amendments was made in this act, which includes the provision for allowing the some non-forest activities in forest without cutting trees or limited cutting with the prior approval of central government. So these modifications or amendments are made by the government later on in 1992, through which there is provision made by the central government for allowing some of the non-forest activities in forest which without cutting the trees or limited cutting of the trees with prior approval of the central government, which is banned earlier. Then these activities are setting of the transmission line, then seismic surveys, then exploration, drilling and hydroelectrical projects. The last activity involves the large scale destruction of the forest, for which prior approval of the center is necessary. So The 1992 amendment also gives the list of the activities for which the state government can use some non-forest activities in forest, but for the hydroelectric project that causing the large scale destruction of the forest, which require prior approval of the center for that activity. Then wildlife sanctuaries, national parks, etc. are totally prohibited for any exploration or survey under this act without prior approval of the central government, even if no tree felling is involved. So for in case of the wildlife sanctuaries or national parks that are totally prohibited by any exploration or any survey under this act, and there is a total mentor of these national parks or wildlife sanctuaries is the central government, and without prior approval of the central government, it is not not permitted any type of exploration or survey under this act. Then cultivation of the tea, coffee, spices, rubber and plants which are cash crops are included under non-forestry activity and not allowed in the reserve forest. So these cash crops or commercial crops are included under the non-forestry activity and are not allowed in reserve forest area. Then next is the Air Prevention and Control of Pollution Act in 1981. So this act provides for prevention, control and abatement of the air pollution, and in the act, air pollution has been defined as the presence of any solid, liquid or gaseous substances including noise in the atmosphere in such a concentration as may be or tend to be harmful to the human beings or any other living creature or plants or the property or enjoyment. So very broader definition of the air pollution is given in this act, and through which the individuals or any defaulters is avoidable, which is causing loss to the properties of the air pollution or air. Then pollution control boards at the central or state level have regulatory authority to implement the Air Act. So by this law, the pollution control boards at the central or state level have regulatory authority to implement this Air Act, and just parallel to the function related to Water Prevention and Control of Pollution Act, the boards perform the similar function related to the improvement of air quality. So just like the Water Act, this Air Act gives the power and same power or similar function related to the improvement of air quality. The boards have to check whether or not industry strictly follows the norms or standard laid down by the board under the section 17 of this act, and regarding the discharge of the emission of any air pollutant, and based upon the analysis report, consent is granted or refused to the industry. So the provision is made in this act that particular board have to check whether the particular industry is following the norms or not, and if the industry is not following the laws and not following the provisions laid down by the boards, and under section 17 of this act, the board has authority to stop or give them consent or refuse to give them consent for that industry activity. Just like a Water Act, this Air Act has provision for defining the constitution, powers and functions of the pollution control boards, funds, account and audit, penalties and procedures. Then section 20 of this act has provision to ensuring emission standards from automobiles, and based upon it, the state government is empowered to issue the instruction to the authority in charge of the registration of the motor vehicle under the Motor Vehicle Act 1939, that is bound to the comply with such instruction. So the section 20 of this act give the power to the state government that it should be given instruction to the authority of in charge of registration of motor vehicle, so that the emission standards must be fulfilled by the automobiles. Then as per the section 19 of this act, in consultation with state pollution control board, the state government may declare an area within the state as air pollution control area and can prohibit the use of any fuel other than approved fuel in the area causing air pollution. So this section 19 of this act provide the additional provision or additional authority to the state pollution control board, through which this state government can declare a particular area as a air pollution control area and restrict the use of particular approved fuel in the area that leads to the minimizing the air pollution of particular area. And appellate authority for this act is, or for the air pollution control is, consisting a single person or three persons appointed by the head of the state governor, is constituted to hear such appeal as filed by the some aggrieved party or industry due to some order made by the state board within 30 days of passing the order. So appellate authority is defined by this law. If any dispute is there, then last is the Environment Protection Act 1986. Some terms related to environment have been described as follows in the act. First, this act defines the what is environment, and it gives the clear-cut definition of environment. This environment includes the water, air and land, and the interrelationship that exists among and between them and human being, all other living organism and properties. So by this law, first time the clear-cut definition of the environment is given. Then environmental pollution. The environmental pollution means the presence of any solid, liquid or gaseous substance present in such a concentration as may be or tend to be injurious to the environment. Then it also define the hazardous substance. Hazardous substance means any substance or preparation which by its physiochemical properties or handling is liable to cause harm to the human being or other living organism, property or the environment. So this law clearly defines environment, environmental pollution and environmental hazardous substances. And the act has given powers to the central government to take measures to protect and improve environment, while the state governments coordinate the action. So this law give original powers to the central government, and in accordance with our state governments coordinate the different action. The most important function of the central government under this act including the setting up of the standards of quality of air, water, soil for various areas and for various purposes. Then maximum permissible limits of the concentration of various environmental pollutants, including noise for the different areas. Then procedures and safeguards for handling hazardous substances. Then prohibition and restriction on the handling of hazardous substances in different areas. The prohibition and restriction on the location of the industries and to carry out the process and operations in the different areas. The procedures and safeguards for the prevention of accidents which may cause environmental pollution and providing for the remedial measures for such accidents. The power of entry and inspection, power of take a sample, etc. under this act lies with the central government or any officer employed by it. So the act gives the important provision for the central government to make the activities, or the central government through this act includes the setting of different standards, then each different standard for each of the different water, air and soil properties and various areas and various purposes. Then different limits of the different pollutants in different areas. So these are the some of the details of the important functions of the central government through this act. and central government have to clear cut setting the various provision for the different properties of different pollutant and different limit for the different pollutants, and each and everything related to the environment, that is what is hazardous substances, how they can handle, what is the prohibition and restriction of the location of the industries, and what are their areas of operation, then what are the procedures and safeguards for preventing the actions which may leads to the environmental pollution, or what are the remedial measures to provide or during that such accidents, and what are the power of entry and inspection or power to take the sample, and all the authority are lies under the central government through this act. Under the Environmental Protection Rules 1986, an amendment was made in 1994 for the Environment Impact Assessment, that is EIA, of various development projects. And there are 29 types of the project listed under the Schedule 1st of the rule, which require clearance from the central government before establishing. So this act clearly mentions the different, that is 29 types of project are listed in the schedule first of that rule, which require a clearance from the central government before establishing. And this law through amendment of 1994 has made provision for environmental impact assessment for various development projects. Under the Environment Protection Act 1986, the central government also made the hazardous waste, that is management and handling rules 1989. Under these rules, it is a responsibility of the occupier to take all practical steps to ensure that such a waste are properly handled and disposed of without any adverse effect. So these hazardous waste management and handling rules 1987, under this rule the occupier has all responsibility to protect the environment. Then there are 18 hazardous waste categories recognized under this rule, and there are guidelines for their proper handling, storage, treatment, transport and disposal, which should be strictly followed by the owner of the industry. So these rules, hazardous waste management and handling rules 1989, given a clear cut categorization of the 18 different hazardous waste, and there is a detailing procedure or guidelines are given for handling, storage, treatment, transport, disposal, and which is available to the industry owner. Then Environment Protection Act 1986 has also made provision for environmental audit as means of the checking whether or not a company is complying with the environmental laws and regulations. So there is provision for environmental audit through which the different activities or different precautions are followed or not by particular industry can be checked. Thus, the ample provision have been made in our country through law for improving the quality of our environment. And through this law, the Indian government gave a clear-cut message that we have to follow the law for improving the quality of our environment, and this is the legal action through which government gave the emphasis, and through this act they made the ample provision for the protecting the environment by the government. So thank you. This video is for educational purpose only and references are as below. Thanks once again.